May it please the court.
All right,
Counsel?
Mr. Candela, I understand you represent the appellant in this case. Did you wish to reserve any time for rebuttal?
I do, Your Honor. Three minutes, please.
So noted. Thank you, counsel. You may proceed.
Your Honor, this case comes to this court on an appeal from a motion to withdraw a plea after sentencing, as bore out by the record. This is Criminal Rule 3.170L, which is different from subsection F. And this is a situation in which, right after the plea, Mr. Calderon experienced some difficulty in his housing and some other areas that we brought immediately back to the court. But I do want to make sure that the record is correct, because there was, in my reply brief, I pointed the court to an email from the Department of Corrections that was emailed to my client the day after the plea, and I want to, and I believe that's at record. That is at record 379, because this is, I guess, this is a very important part of what's going on here. In this case, my client accepted a plea on the day of, on the day of trial, and the plea called for certain criteria. One being that he would be subject to the 1,000-foot rule, which this court is well aware is the standard condition in Florida, that sex offenders and certain offenses have to live within cannot live within 1,000 feet of certain.
Mr. Candela, I know he got surprised by the Deltona 2,500-foot rule, and that's kind of where you're headed with this. And the problem I've had with your argument, and the question that I don't understand, is he was trying to live with his grandmother in Deltona. His grandmother's house was 800 feet from a park, which would violate the 1,000-foot rule. So when he entered the plea, he knew he was going to have a problem with his grandmother's house because it was 800 feet from the park, not over 1,000 feet from the park. And then later he learned about the 2,500-foot rule. So I have a hard time really seeing the relevance of the 2,500-foot rule if he couldn't meet the 1,000-foot rule anyway. So help me with that, because he knew going in, or he should have known, he knew or should have known his grandmother's house was 800 feet from the park.
And understanding that point, Judge Morris, the problem is that that sometimes courts and courts in Hillsborough have allowed variances.
But he didn't have one.
But if you read the email, he couldn't get one. Even if he got one,
he was hoping for a variance. And at the time he entered the plea, he did not have that in the bag. But he was hopeful that he could, just like he was hopeful that he could transfer to Connecticut, and then he was surprised that Connecticut wouldn't accommodate the electronic monitoring called for under the Jessica Lunsford Act.
Correct.
So on two bases, he didn't do his homework, or his lawyer didn't do his homework.
Correct.
Right?
And that if it's the lawyer problem, then we come into
3.850.
Well, we come into the situation that I pointed out in the reply brief that I explained a little clearer, that the appellee was not having both of these are both. So
the standard at 3.850 is prejudice as opposed to manifest injustice under the rule.
Correct.
Right? So again, I don't even, how is he prejudiced if at the time he entered the plea, there were two places he wanted to live, with his grandmother in Deltona and his mother in Connecticut. He knew his grandmother's house was 800 feet from the park, or he should have known that. Didn't qualify for the 1,000-foot rule. He was told by Judge Nash in the plea colloquy, I don't object to you going to Connecticut, but it's up to them. So he didn't have that in the bag either.
Right, so, but you're on a living.
So, I mean, how is he prejudiced if at the time he entered the plea, these were unknowns, they were hoped for, but unknowns?
Well, part of the problem is this, Your Honor, is that if you can't live anywhere and you're not from Florida originally.
That I get, Mr. Kendall. I totally am sympathetic to that. I get that. What we have to focus on is at the time of the plea, What did he know and what was the decision he made? And we know that he should have known his grandmother's house in Deltona was 800 feet from the park. He knew that the Connecticut transfer was not in the bag. You know, apparently it wasn't thoroughly checked out. So the question is, he knew there were two issues which were not completely concrete, and he still pled. So how is he prejudiced?
If he relied on information from his attorney that was incorrect, then that goes back to the.
We don't have that information. There's not in our record that his lawyer said to him, don't worry, you can transfer to Connecticut.
No, but he has in the record there from the hearing. In my reply brief, we go through the questioning and answer, and he specifically was under the impression, based on his conversation with his attorney, that he could live at that one house.
Oh, it was more like might. You know,
But the other part,
but
of
it
the
wasn't for
385
sure. And he knew it was 800 feet. He was hoping for a variance, which he may or may not have gotten.
Your Honor, but when a non-attorney seeks the counsel of an attorney and doesn't have the schooling or the training or any of the other aspects of what we do for a living, Your Honor, and the other judges and the other attorneys, and they ask questions, they don't always know what to ask. And if he's asking, hey, can I live at this place? And it's hope or might, he's relying on it. He doesn't know.
He may be, but he's still been told, I hope or might, you know, and you don't need to be a lawyer to know it ain't concrete.
Right. I agree with that.
Well, isn't there another difficulty if you're asking us to look in the context of a 3.850, since this is a plea case, in light of the charges that he was facing, wouldn't he also have to establish that he would have gone to trial and exposed himself to the risk of conviction?
Yes, Your Honor, but here's the thing
And
that
we
I'm bringing
can't
up.
determine that from this record, can we, at this time?
I don't know that we can or we cannot, Your Honor, but what I can say to you is that one of the arguments at the withdrawal plea colloquy is that it would be absurd that he would want to go to trial. Why would somebody on a departure sentence want to go to trial? And that's why
well, in his case, he had sex multiple times with a 14-year-old, and he was exposed to 45 years in prison, and he got probation.
Correct. And then I would point the court to the McCoy case, McCoy versus Louisiana, in which the United States Supreme Court basically said it doesn't matter what the penalty would be, because in McCoy he was facing life, and as the court well knows in the McCoy case, it didn't really matter. McCoy wanted a trial, and in that case, just real brief, McCoy was a situation with a death penalty case, which his attorney in McCoy admitted guilt to try to gain some curry with the jurors to move on to second phase. In McCoy didn't want him to do that. McCoy wanted to put on, I believe, an alibi or some cockamamie defense that wouldn't have worked. And what the Supreme Court ruling on this case said, it doesn't matter what the penalty is. It doesn't matter how asinine the want is to go to trial. The Sixth Amendment says you have a right to a trial, you get a trial. So this whole idea.
But it also says in those line of cases, there are certain things that only the defendant can raise or waive, pardon me, right to a trial by a jury, not guilty plea, and those things. So there's a crossover. Some of that was not exactly what we expected in the 3850 context from McCoy. It came out, I think Justice Ginsburg wrote a little differently than some of us were thinking the case might go. But what she said was, basic, if I recall correctly, if you say you're not guilty, at that point, that's your position. You have that right to do it. And then counsel has to make strategy accordingly.
Yes, but
it's been a while. Forgive me from I've looked at that. So
well, no, but McCoy also takes it one step farther, because the analysis from Louisiana was, well, this is, he's looking at the death penalty. A lot of defense attorneys make that determination, and the Supreme Court said no, it's whatever the penalty is not a deriving factor for this. It's what is the decision of the client. But the reason I brought up the 3.850 is because both 3.170L and 3.850 are both post-conviction remedies. that have completely different standards for the same thing in this situation, which is attorney misadvice or misunderstanding. Because the LaRue case says if there's misunderstanding, then the remedy is withdraw the plea. But under 3.170L, we have to make out this mythical manifest injustice, which is never really defined. It sounds terrible. It's got to be a manifest injustice. But as this court does regularly on when ruling on 3.850s, if there's a misunderstanding, the court sends it back and says, hey, if he wants to withdraw his plea, let him withdraw his plea. So the evidence, I believe, at the hearing is that he relied on counsel to.
Counsel, if we followed that rationale, wouldn't we see this over and over and over again every time somebody wants to take the shot at being approved for some zone or some transfer to another state? All attorney has to say is, I think you're going to be able to do it. Then they come back and say, I advise them that and give them another shot.
I think it's a consequence of I understand the floodgate argument. The problem is I think it's a consequence of this 1,000-foot rule and what is and is not compliant. As this court well knows, somebody could open up a daycare by simply getting a daycare license next to your house.
Isn't that burden on the attorney and their client? The judge asked the questions, your client answered the questions, and as Judge Morris already pointed out, at the point in time, he already wasn't in compliance, and there was no guarantees that were given by the judge.
Well, I believe that at the time he pled, I thought he believed he was in compliance, Your Honor, because he had bonded out, and then we had to take a writ, as this court is well aware of, habeas on. He was late to court and he was taken in, and then he was released back out to the address that he was living at. So the circumstances suggest that he did not have pre-knowledge that his address wasn't going to work. Number one. Number two,
even if that were the case, if a bus stop was added later on, there could be additional requirements for him. If a daycare was added, those sort of things. I mean, you're trying to go back and second guess what was going at the time when you and your client would have been the ones in the best position to know.
Well, Your Honor, I go back to the contract principles. This court and the other districts have said these are contracts. And if this was a civil contract, as I pointed out, and the terms got jumbled up as we were going through, mistake would be a contract offense. It would be pled and it would move forward through the system. It turns out that when we're in the criminal justice system, mistake becomes this, whoa, sorry, you should have known. You should have known, and too bad, so sad. Which in the civil sense, we're not dealing with liberty. We're dealing with, it should be a more protective in the criminal justice system and not less. And if that is the case, then
it's not as though he's losing the benefit of his plea. He's still getting the benefit of his plea. It's only that he can't live where he was hoping, as Judge Morris pointed out. I mean, there's a lot of hope in here, and there's a lot of ideas in here for him to be able to get the benefit of 10 years of probation versus lengthy prison sentence.
I know, but when you destabilize a sex offender, as this court well aware, it becomes problematic. So if we begin to say, well, you can't live here or you can't live there, it bounces the person around. I don't know how many times I don't know, and the record doesn't bear out how many times he's moved since his plea, but it's been quite a few times. But if we look at Judge Nash's ruling, Judge Nash only ruled on the Connecticut part, and then his ruling, which is oral, it wasn't written, said, well, he just doesn't like where he lives. That didn't even answer the question presented. So, I mean, if that's the case, then this court could remand this back for further information on that, because the court didn't really answer the question by saying he just doesn't like where he lives. That's not really the issue. The issue is was there a material mistake in forming, in entering into this plea, which was part of what was going on. But I understand the concern. You know, one of the things that the appellee brought up was the Bradford case, and that's a case from this court from 2004. But I think Bradford, while it mentions manifest injustice, doesn't really, again, it doesn't define what that means. What does a defendant have to prove? What set of circumstances? You know, in a civil context, it's like what's bad faith? It's this grand concept that never is defined for what the insurers can and cannot do. It's the same thing with this manifest injustice. What is it? Is it if it's prejudice? How does it apply? Is it substantive or is it a procedural? And in those terms,
in essence, you even said in your own argument that there's this, I'll call it obstacle course, that's out there for people who enter these pleas to be able to get to the finish line of their probation. So for the attorney to properly advise his client or her clients that this is what you're going to be up against, it sounds like you're wanting to have some sort of a guarantee that the court's going to give them that at least your first residence is going to qualify, that there's some additional promises, which certainly if the legislature wanted to do that, they could say, you know, you have to make sure there's a location that they're going to be able to live for some period of time. But that's not what the law says. And you're trying to add additional requirements to the law that this judge should have looked into to make sure that your client was going to have a safe place to go and reside. And that's not ever been the court's responsibility.
well, I don't know that Judge Stargell, I don't know that that argument has ever been the way that you posed it has ever been raised. I think that living is not a collateral, but a substantive right. Obviously, if you have no place to live, it's very hard to comply with the terms and conditions of a sex offender sentence, because the legislators also added a series of crimes. If you do not register, if you do not do all these other things, that you are immediately going to be in violation of the law.
Mr. Candela, I need to advise you, you're at 17.
I'm at 17. Then
Yes, sir.
let me just sum this up, and then I will yield my time. With the point of the sex offender sanctions and those, I don't think it was the intent of any of the parties that my client plead and immediately violate. That makes no sense. If that was the intent, then this thing was sunk before it even started, and that just doesn't seem to it violates fundamental fairness. I yield my time at this point, Your Honor.
Thank you, counsel.
Good morning, and may it please the court. Todd Chapman on behalf of the appellee of the state of Florida.
Just a second, Mr. Chapman. Let me clear the time clock so I don't short you. Otherwise, you're already at 18. There we go. Thank you, sir.
The issue before this court is whether the trial court abused its discretion in finding that there was no manifest injustice in denying appellant's motion to withdraw his plea. And the answer is clearly it did not. A detailed written plea agreement, as well as a detailed plea colloquy, advised appellant of the terms of his plea. Now, as for transferring his probation to Connecticut, as Judge Morris pointed out, the trial court clearly advised appellant that it would be up to the state of Connecticut whether or not that was approved. Appellant was also clearly on notice that he could not live within 1,000 feet of a park or a school. As his grandmother's residence was within 1,000 feet, he was on notice that this was not an acceptable residence. As for the 2,500-foot Deltona restriction, this is irrelevant for the grandmother's residence because, again, it was within the 1,000 feet. And also, as I noted, the Deltona ordinance was never presented to the lower court. It was the Land Florida ordinance that was presented. And I would further point out that Condition 5 of appellant's probation requires that he live without violating any law. So the Deltona law would come under that general restriction on violating any law. And I would also like to point out, and I did file this, a supplemental authority early last week, the Raul Calderon case out of the Third Circuit. And that case also dealt with a Miami ordinance, a 2,500-foot Miami ordinance on sex offenders. And the Third District held that that ordinance was not void as being preempted, and notes the defendant must obey all laws because that defendant also had the had the same restriction that appellant had on condition 5. If there are no questions, I would ask that the judgment and sentence be affirmed.
Thank you, counsel. Let me check. Nope, I don't think there are any questions. So then we will proceed to rebuttal at this stage. Let me do, you have 2.5 minutes left, counsel, Mr.
Thank you,
Candela.
Your Honor. Your Honor, I would just close by saying a couple of things. I did receive the supplemental authority. I'm not sure what the third district is looking at here, but the case that I, in my reply brief, I pointed out that.
Is that issue teed up though, Mr. Candela? Because we don't have the city of Deltona represented. Isn't that a separate action to challenge that?
Here's the thing. I'm not sure, in all fairness, I'm not sure how to raise the issue. Hillsborough would be ruling on a Volusia County municipalities ordinance because there was a sentence crossover. I don't know how to raise it. I don't know where you would raise it. Do you raise it in Volusia? Do you raise it in Hillsborough? And
You may need to file a deck action somewhere or challenge the constitutionality, assuming that your client has standing to bring it.
yes,
A
Your
couple
Honor,
of things that you'd have to go through. I mean, you're right. There's a number of prerequisites that you would have to duly investigate.
correct. But
And in essence, if that could be done, then every time any municipality had a statute that was arguably unconstitutional, every sex offender in the state could say, I wanted to move there, but for this, and then go back. So I think we have to focus on what the facts were in this case at the time it was entered and whether it was a manifest injustice.
yes, Your Honor, and I absolutely agree. But based on the facts of this case, my client did live in DeLand at the time of the plea, so I think that he would make that. However, I don't know how to raise it, and that's in all fairness. I don't know whether it would be a deck action, because you can't bring a deck action in criminal court. He'd have to bring a civil action, which is separate and apart from the fact that this is going to be imposed on him in a criminal court, which that's a
But it
rare.
still doesn't change the fact that those would have been issues that he knew or should have known at the time that he agreed to enter this plea and accept the benefit of 10 years of probation versus whatever else a judge might have sentenced him to had he gone to trial.
Well, yes, Your Honor, but if DOC is gonna impose a 2,500 rule, let's say he finds 1,000-foot compliance, and they're not gonna impose it. They're gonna, according to the only piece of evidence that was admitted without objection and argued at the hearing, this is the only evidence before this court is the DOC is gonna impose this 2,500 foot. So even if the terms are 1,000 foot, so let's say he finds 1,000 foot, they're not gonna honor it.
They also said they wouldn't honor a variance as well, didn't they?
They also said that, but I'm pretty sure the case law says that a court can order a variance.
Well, here's the tough part about that is the separation of powers issue. They're the executive branch. We're the judicial branch. Unless an issue is teed up and there are parties, briefing and arguing the positions, I don't know how we tell the DOC what to do ever. Unless it's been raised in a case and it's been teed up and the parties we got a DOT lawyer, a DOC lawyer here with us. I don't know how the judicial branch tells the executive branch what to do.
You would need a judicial authority with jurisdiction over that entity. At this point, we don't have any jurisdiction over them. They're not a party.
Correct, but they're going to enforce the terms and conditions of the plea under the criminal punishment code.
Well, they have to violate them. They have to go to the trial court, and the trial court has to find two standards: willful, and intentional violation, I think it is. And if the trial court has said, I approve your residence, then he may have that which he wishes. And I need to advise you that we are at 4 minutes, so your time has expired.
Thank you.
We've asked you too many questions. I'm sorry about that.
No,
Is
not a problem.
there anything you'd like to say in 30 seconds?
Just that I would ask that the trial court reverse the ruling, or that the appellate court reverse the ruling of the trial court and send this back for a trial.
Thank you, counsel. Thank
you.
you both. It was an interesting case and kind of a difficult position for the appellant to go through. It's an interesting quandary. So we'll take it under advisement. Thank you both. Stay well, please. I think they will transfer you back to your destination.